the state of Delaware will now draw near and give their attendance. The court is now open. God save the state and the honorable court. Please be seated.
Welcome everyone. Good morning. We are delighted to be at the law school this morning. Please make your introductions.
Thank you, Your Honor. Good morning. May it please the court. John Day from Prickett, Jones & Elliott on behalf of the plaintiffs below and Appellee. I'm joined by my colleagues Kevin Davenport and erred, and I'm also joined by plaintiff below and Appellee Deann and Totta.
Welcome.
Good morning, Your Honors. May it please the court, my name is Kevin Connors with the law firm Marshall, Kennedy, Warner, Coleman, and Godwin, representing appellant defendant below. I am joined today by my colleagues, Michael McGinley of the Deckard LLP law firm, who will be arguing on behalf of appellant, and his colleague, Richard Horvath, from the Deckard LLP firm, and also from Patrick Cannell from Kaufman, Balowich, and Volek from New York City.
Welcome everyone.
Thank you, Your Honor.
You may proceed.
Good morning, Your Honors, and may it please the court. Michael McGinley of Deckard LLP on behalf of appellant CCSB Financial Group. The decision below committed three independent reversible errors. First, it refused to apply the voting limitation and conclusive and binding provisions that CCSB's stockholders universally agreed to adopt in the company's founding charter. These provisions, which were adopted on a clear day, long before the dispute at issue in this case, serve an important and valuable purpose. Consistent with the Federal Change in Bank Control Act, they prevent a single stockholder or group of stockholders acting in concert from quickly wresting control of the company by voting an outsized block of shares that constitute more than 10% of the company's outstanding stock. Similar provisions are found in the charters of many other community banks, and for good reason. They ensure stability and prevent the sort of takeover efforts that Mr. Johnson, who is the controlling stockholder and a board member of one of CCSB's competitor banks, undertook here. Foreseeing that this voting limitation provision would naturally lead to disputes, the charter also specifies that the business judgment rule standard of review applies to board actions applying the provision. Specifically, the company's stockholders agreed that, quote, any constructions, applications, or determinations made by the board of directors in good faith on the basis of such information and assistance as was then reasonably available would be, quote, conclusive and binding upon the corporation and its stockholders. This provision also makes good sense. It reinforces the voting limitation by creating a presumption that can be rebutted that the board's interpretation and application of that critical provision was permissible. Not only are these provisions consistent with Delaware law and sound public policy, including SIPCA, but they are entitled to the long-standing respect that Delaware courts have afforded to contractual terms between corporations and their stockholders. Indeed, because these provisions have existed in CCSB's charter from the beginning, all of the company's stockholders, including Mr. Johnson and Mr. Watson, assented to and are bound by them. The decision below conflated this standard of review with the standard of conduct and incorrectly held that Delaware law prohibited CCSB's stockholders from specifying a standard of review. That category error is legally incorrect. While the courts have held that corporations, unlike alternative business entities, cannot eliminate or alter the standard of conduct, those decisions do not prohibit stockholders from specifying in their founding charter that a specific standard of review should be applied to certain board actions. In fact, by refusing to apply the standard of review specified in the charter, the decision below violated the fundamental freedom of contract principles that animate Delaware law. Second, after eschewing the contractually specified business judgment standard of review, the decision below erroneously applied the Blasius standard of review instead. As a threshold matter, even if intermediate scrutiny were to apply, which we do not believe that it does, the proper standard is unical rather than Blasius.
But you didn't argue that below, did you?
We did, Your Honor.
Well, what I saw was a reference to what standard of review should apply, but did you specifically argue to the trial court that the upheld standard should apply?
Yes, Your Honor, and where this came up predominantly was on the eve of trial, a decision called strategic investment came down, and CCSB sent that decision to the chancellor, and at trial that decision was extensively discussed. That decision itself grapples with whether upheld or Blasius applies in a setting like this, where you have something that was adopted on a clear day and then applied consistent with those provisions. And what strategic investment ultimately says is that the reasonableness approach is what applies. And so in the trial, in the transcript of trial, there's extensive discussion of what standards should apply. CCSB specifically argues that that reasonableness approach should apply. And then also, Your Honor, in the chancellor's decision, she in multiple places recognizes upheld and seemingly seems to implicitly grapple with whether upheld or Blasius applies, but then ultimately goes ahead and applies Blasius. So we do think that that issue is fully preserved. It's been fully briefed by the parties in front of this court, and we also think it's important, given that the issue was raised below and discussed and addressed in the chancellor's decision, that this court should provide guidance as to which of the two standards applies, because it really does matter. And I think this court and other courts have recognized that there is a distinction between those two standards of review. We think that to be clear, we do think we can meet either of them because we do think there's a compelling justification here. But we think it's even more clear that there was a reason that the voting limitation provision, the conclusive and binding, and the acting in concert provisions working together were both reasonable and proportional.
Let me ask you this. If we agree with the chancellor that you can't alter the standard of review, and she made a factual determination on the acting in concert point, do we even have to reach the Blasius standard of review question?
So with respect, I want to dispute the premise that she made a factual conclusion on the acting in concert. I think what really animated her decision on that point was a legal error. That was sort of a double legal error, where she first adopted an overly narrow definition of what acting in concert could be, and a definition that's not consistent with the CIPCA regulations that the federal government has promulgated. We think that the CIPCA definition is the proper one because it's a term of art that's incorporated into the charter with CIPCA as the background. But
let me reframe my question. If we agree with her, whatever the standard of review is on both the alteration of the standard review prohibition and on the acting in concert, we don't need to go any further to decide the case.
I think if what you're asking me is if you agree with her on those two things, that may be right, but I would say you shouldn't agree with her on those things.
I understand.
Yeah, and I think even beyond just the definition itself, we do think she adopted the wrong definition. Our briefing gets into the details of that. But I think even if you look at on her own definition, I think it's a legally erroneous application of that definition, because at a minimum, there was clearly an understanding here between Mr. Johnson and David Watson that the shares that were transferred were going to be voted in favor of Chase Watson, who's David Watson's son. And also under the CIPCA regulations, there's a presumption that close family members are acting in concert. And that's not, we don't have to rely entirely on that presumption, because in the evidence it shows that, amongst other things, Mr. Johnson drafted the response that David Watson sent to the CCSB board, and the record shows that Mr. Watson wasn't even involved in that drafting. There's an email in the record that shows he's not copied on an exchange of the draft, and then in his own deposition testimony, he indicates that he wasn't involved. And what that letter says is that Mr. Watson is going to vote for his son. And so at a minimum, that shows an understanding between the two of them. And I think the pattern...
Is your argument that the chancellor's finding on that point was clearly erroneous?
So you could look at it. You could look at it two different ways, Your Honor. And what we think is it's probably a mixed question, where you have an application of the legal standard to the facts at hand. And I don't think that she found an incorrect fact as to sort of whether certain things occurred. She acknowledges that the things that we say satisfy the standard occurred. So really what I think is happening is she's applying the legal standard to those facts. That's a mixed question that I think should be governed more like a legal question than a fact question. But even if you were to look at whether the overall acting in concert conclusion is a fact question, we do think is clearly erroneous because of the fact that I just mentioned, but also the fact that you have record evidence that Mr. Johnson sold the stocks to Mr. Watson on the eve of the record date and explicitly instructed Ms. Totta to do it as soon as possible to, quote, beat the record date. You have the history of the Robb litigation where a court in Missouri held that Mr. Johnson orchestrated an unlawful foreclosure sale that then ended up in Mr. Johnson orchestrated that foreclosure sale that ended up in Mr. Watson first acquiring his first tranche of CCSB stock in an effort to gain control of the company. That's the holding of that court in Missouri, the Robb litigation. And then you have record evidence that after that foreclosure sale, in an Excel spreadsheet where Mr. Johnson is identifying his, quote, that shows the shares that he holds in beneficial ownership, he identifies those Watson shares. And so there's a history showing that there has been, at a minimum, an understanding between these two gentlemen that the shares were going to be held so they could act in concert. And I think especially when you're faced with a set of facts where Mr. Watson's own son is amongst the nominees that are nominated by Mr. Johnson, it just blinks reality to say that there's not acting in concert in that setting.
I'd like to take you back to your statement that you're fine under either Blasius or Unical. As I understand your argument, I want to make sure I have it right. The compelling justification you point to was to protect the company's stockholders from Mr. Johnson taking control and considering sale of the bank. Do I have that right?
I don't think that's quite right, Your Honor. I think that's how the decision below characterizes it. I think...
What's wrong with that characterization?
It's because it suggests that sort of out of the blue, with apropos of nothing, that was the purpose of the board, and in a sort of paternalistic way that at times this court has said is unacceptable. What we would say that is different, and I think meaningfully different, is that the compelling justification is that the board was enforcing provisions in a charter that all of the stockholders had assented to from the very beginning.
Well, on that point, if I may interrupt.
Sure.
It seems to me that two sides are ships passing in the night, and that you want us to focus on the adoption of the voting limitation and apply standards to that, whereas your friends are focused, as I understand the arguments, on the invocation of the voting limitation and the application under the facts of this case. Would you mind addressing that distinction?
No, I think you're right that there is a fundamental difference of sort of the framework that we're presenting and that they're presenting. We obviously think ours is correct, and I think part of what's motivating the other side's framing of it is they want to fit this into Blasius, and the reason it doesn't fit into Blasius is that the classic Blasius case is one where the board adopts some new mechanism or does something unilaterally that's not just applying a pre-existing set of rules, but it alters the bylaws or does something to interfere with the voting rights. Whereas here, this is the founding charter of the company. These provisions have existed from the beginning. They were crafted, presumably, to mirror CIBCA. They're obviously consistent with CIBCA. They serve the same critical public policy goals that CIBCA serves. And so this is just a straightforward application of those. The board did not adopt a new provision, didn't add to anything in the charter, didn't subtract from anything in the charter. And the mere fact that this was the first time that the acting in concert provision had to be applied is just by virtue of the fact that this is a particularly aggressive takeover effort. And the fact that nobody else has triggered in the past doesn't mean that it didn't exist.
I'd like to, if I could just interrupt you, focus on something a little bit more fundamental. And that is, what is it that a corporate charter can do versus in the alternative entity context? Would you agree with me that there are certain limitations in the corporate context in terms of what a charter can do regarding limitations on fiduciary duty elimination that are not available, that are available in the alternative entity context? For example, in the Salzburg case, we said a corporate charter, if people have immense freedom to enact corporate charters. However, we said provided statutory parameters and judicially imposed principles of fiduciary duty are honored. And we also said companies have great leeway to structure their relations, but subject to relatively loose statutory constraints and to the policing of director misconduct through equitable review. So even in Salzburg, where we recognized, vast scope of corporate charters, there are limitations on them.
I do agree with that, Your Honor, and this gets to the heart of where we say that there was sort of a conflation or category error between standard of conduct and standard of review. And we are not in any way arguing that the charter was allowed to alter the standard of conduct, i.e. the duty of care or loyalty, but that the standard of review has long been recognized as distinct from that. It's a sort of, the two work in hand in some way. But our point is, what the statutes say is that you can alter the standard of conduct, you can eliminate the standard of conduct in the alternative entities space, but this court has said you can't do that in the corporate structure. But it's never said.
But the charter says the decision of the board is final and binding, and there's no review. Is that permissible?
Well, but with respect, I would quibble a bit with the notion that there's no review. Under the business judgment rule, there's always still review. It's just that the presumption goes in favor of the company and it can be rebutted. And I think the decision below fully recognized that the language used in the charter here is consistent with and parallels the language for business judgment rule. And this court has never and shouldn't recognize that business judgment rule is a sort of rubber stamp for the company. It just alters sort of where you start in the standard of review when determining whether or not the standard of conduct was satisfied. I see that I'm eating into my rebuttal time. I'm happy to answer any other questions now, but otherwise I would reserve the remainder of my time.
Thank you.
Thank you.
May it please the court. After trial, the Court of Chancery determined that CCSB's directors wrongly interpreted and applied the certificate of incorporation when they excluded votes that were cast for plaintiff's nominees, changing the outcome of a director election. The trial court's post-trial decision should be affirmed on two independent grounds. First, the Court of Chancery correctly determined that CCSB's board misinterpreted and misapplied its certificate of incorporation. And second, the Court of Chancery correctly determined that under Blasius, the CCSB board applied the voting limitation inequitably. I will address CCSB's arguments in the following order. First, I will address their argument that the conclusive and binding provision mandates business judgment review. Second, consistent with Schnell versus Chriscraft, I will address whether what they did was legal and whether what the board did was equitable. Turning to the conclusive and binding provision. As the Court of Chancery recognized, because standard of review can be determinative, CCSB effectively argues that a certificate can eliminate fiduciary duties, which the court characterized as, quote, resetting the orientation of corporate law. Now, CCSB today acknowledges that the corporation certificate cannot eliminate fiduciary duties, but they offer no limiting principle as to why their argument that applies to standard of review cannot apply to fiduciary duties themselves. And CCSB's position, if accepted, initiates sections 111 and 225 of the DGCL, foreclosing review of the board's application of the voting limitation unless there is a showing of bad faith. Now, the Court of Chancery ignores,
What about the distinction they're making between standard of conduct and standard of review?
So it certainly is a distinction, but it's a distinction the Court of Chancery recognized. The Court of Chancery stated explicitly that it was rejecting CCSB's argument about standard of review. And it recognized that standard of conduct and standard of review go hand in hand. And that standard of review is how the court polices standard of conduct. And the Court of Chancery went through several authorities, many pages of its opinion, explaining why CCSB's argument about standard of review is wrong. And for example, as the trial court noted, authorities interpreting Section 152 of the DGCL rebut CCSB's argument. Under Section 152, absent actual fraud, directors' judgments about the value of consideration received for stock are, quote, shall be conclusive. But as the Court of Chancery recognized, and it's in Parfee versus Mirror Image Holdings, the court had previously reviewed the case law and authorities interpreting Section 152 and found that it does not displace fiduciary duties or leave the court powerless absent fraud. Now, here what CCSB primarily relies upon in their briefing is Corwin and MFW, claiming these cases show that stockholders can change the standard of review. Those cases are inapt. Both Corwin and MFW apply equitable standards of review to equitable duties. They do not deal with certificate provisions. They deal with fully informed stockholder votes on specific acts. And they provide no authority for an ex ante waiver of standard of review. And I would like to just note that, as the court picked up on, the plain language of CCSB's certificate does not support their argument here. The conclusive and binding provision says just that. The board's determination is conclusive and binding. As the Court of Chancery noted, the prefatory language about good faith mirrors the business judgment standard, but below they argued the board's determination is conclusive and binding, and that's that. The certificate does not mention any standard of review, and it does not mention the court. So for those reasons, we believe that CCSB is erroneous in their argument that the certificate changes the standard of review. And we just should also note for the record that we don't believe the conclusive binding provision was ever even triggered because the board did act in bad faith. Turning to the question of whether the board's actions were legal. Under the first prong of Schnell, the court below had to determine if the director's actions were legally valid. They were not because the board misconstrued the voting limitation. The pertinent certificate provision contains the phrase acting in concert, which is not defined. The Court of Chancery, relying on the terms of CCSB certificate, federal securities laws, and regulations in Section 203 of the DGCL, held that acting in concert cannot go beyond an agreement, arrangement, or understanding regarding the voting of stock.
I think their main argument, at least today, is that there was an understanding that the chancellor erred in not finding there was an understanding.
We respectfully disagree with that. The chancellor went through the evidence. The sale from Mr. Johnson to DEW was at market price. DEW paid over $300,000 for the stock. It was reported to the IRS and the Federal Reserve Bank, and there was sworn testimony that there was no agreement or arrangement concerning the voting of stock. And as the Court of Chancery noted, CCSB below argued strenuously that when company insiders were selling stock to each other and purchasing stock from friendly stockholders because they wanted to keep it in friendly hands, that was not acting in concert. We have to keep in mind that below, CCSB faced an argument or a dilemma that any broad application of the acting in concert provision would boomerang right back on the board, because for years they had been selling stock to each other and purchasing stock from insiders. So CCSB below had to argue for a very narrow definition of acting in concert, which is not the definition they're applying today. And under CCSB's definition, proffered below, what Mr. Watson and Mr. Johnson did was not acting in concert. Today, CCSB also asserts this new argument about the Change in Bank Control Act, and they contend that it's relevant to the certificate's definition of acting in concert. That argument was waived. In the court below, CCSB never argued that definitions from CCSB informed the definition of acting in concert. CCSB never argued the voting limitation was adopted to further CCSB. CCSB never argued the board was furthering CCSB in applying the voting limitation. And in its opening brief, CCSB did not acknowledge that it didn't make those arguments below and contended it should be considered in the interest of justice. And even if this argument is considered, it's wrong. The voting limitation in the certificate does not mention CCSB. Instead, it expressly adopts terms from federal securities laws. And even if CCSB had any bearing, its presumptions are rebuttable and rebutted on this record. The Court of Chancery correctly interpreted the factual record and determined that the plaintiffs met their burden at trial, showed that the CCSB board misapplied the voting limitation when aggregating the holdings of DEW and Mr. Johnson, and that finding is entitled to considerable deference. Turning to whether the board's actions were legal or equitable in the standard of review. And looking at the second prong of Schnell, the Court of Chancery correctly held that Blasius provides the appropriate standard of review because the CCSB board interfered with the effective exercise of the stockholder franchise in a contested director election. The voting limitation states that a holder of more than 10% of CCSB stock shall not, quote, be entitled or permitted to any vote in respect of the shares held in excess, unquote, of that 10% limit. But Mr. Johnson, DEW, and all other stockholders were permitted to vote all of their stock without any disclosure that their votes would not be counted.
Mr. Day, I'd like to echo the question Chief Justice Sainz asked. If we were to agree with the Chancellor's decision on the acting in concert issue, do we need to also address the issue of whether Blasius or Unical apply?
No, if the board applied the certificate incorrectly, then the Court of Chancery can be affirmed. That's an independent ground.
Well, let's look at it the other way. If we did not agree with that, if we were addressing Blasius or Blasius, everyone says that, and Unical, does the case turn out differently if we were to apply the Unical standard as opposed to the Blasius standard?
No, the case does not turn out any differently if Unical is applied. As this Court has recognized before, Unical and Blasius are sometimes complementary. They can be applied together or they can be applied sequentially. And CCSB's argument that the trial court erred in not applying Unical was waived. But when the Court looks at the Court of Chancery's findings, you can see that the Chancellor found that the board's determination that there was some sort of threat from Mr. Johnson was not well-founded. As a factual matter, there was no threat to respond to. Mr. Johnson was a long-time stockholder. Nothing's happening quickly here. This is a company that has shares that trade thinly over the counter. He can't quickly increase his holdings. He's a 10-year stockholder. Mr. Watson is a 5-year stockholder. This is not any sort of takeover. They're nominating directors who Mr. Johnson acknowledged would have fiduciary duties and would make their own independent judgment about what they would do. So there was no threat to begin with. And on that front alone, we went under Unical. But turning to whether the board's response is proportional, this record is very clear that the board's response was not proportional. They precluded stockholders from voting, which is one of the things a defensive device cannot do. As the Court of Chancery held in Utopica versus American Alliance, defensive devices can be used to stop a rapid accumulation of stock that could result in stockholders, existing stockholders, being treated unfairly. But it cannot be applied to simply stop a stockholder vote. It cannot be applied to just stop corporate democracy. And even if it was permissible, it was inequitable here because it was applied only to the dissenting slate of nominees and their supporters. This is not a situation where the board invoked a poison pill and laid clear rules of the road for everybody that stopped all comers from coming in and increasing their holdings. This is a situation where the board, or more precisely Mr. Bucera on his own, did an investigation, investigated only Mr. Johnson and people he thought were affiliates of Mr. Johnson, made his own determination that Mr. Johnson was acting in concert with others, reported that to the board in a process that was not transparent, in a process that was not independent. His seat was up for election, and in a process that was not overseen by independent counsel. So this is not like a poison pill or any other defensive device that stops all comers and kind of puts a pause on shareholdings. This was applied only to one set of stockholders, Park and its supporters, even when the board and other friendly stockholders were engaging in the same conduct. So on that basis alone, the board's conduct was inequitable, and the Court of Chancery should be affirmed.
Mr. Day, I think your friends characterized the acting in concert with finding by the Chancellor as a mixed question of fact and law. And how much deference do we give the Chancellor's finding when this was decided on a paper record? We can read the paper record just like the Chancellor did, right?
Certainly, Your Honor. But the parties agreed to a trial on the paper record, and that means that the same standards of review, I would think, apply. Even though the parties did not present live testimony, the Court of Chancery often has a trial where you have some witnesses but you have a very comprehensive paper record. A lot of the Chancery Court judges like to talk about how the paper record is more reliable than the live witnesses. And those decisions get the same amount of deference, I believe, and believe should here. Unless Your Honor has any more questions.
I'd like to ask you about the fee issue. I realize it wasn't the subject. Why? Your friends argued that the benefit here was, for all intents and purposes, a benefit personal to certain shareholders and not the company. I realize that the court said, oh, it sort of was good as a therapeutic matter to enforce the stockholder franchise, but would you mind addressing why this is a appropriate case for application of the corporate benefit doctrine?
Yes, Your Honor. So the plaintiffs obtained a benefit for all CCSB stockholders. As Your Honor suggested, they obtained an authoritative ruling on the correct interpretation and application of the voting provision. And on that basis alone, fees are warranted. That benefits CCSB and its stockholders. Keep in mind, this provision was never invoked before. CCSB made no disclosures about how they were interpreting the conclusive and binding, the voting limitation and the acting in concert language before. So now, the Court of Chancery, because of plaintiff's efforts, have provided rules of the road going forward. But secondly, and to Your Honor's question, what plaintiff did was vindicated the stockholder vote writ large. Keep in mind that the board here controlled over 20%, board and company insiders controlled over 20% of the company's stock. Mr. Johnson had about 10%. The vast majority of votes that were for Park's nominees were from stockholders unaffiliated with Park, about 2/3 of that vote. So this is a vindication of the stockholder vote writ large. It's not a case like in Kaiser versus Curtis, where one controller was substituted with another, which the Court of Chancery found was, hardly a thrilling victory for the minority stockholders. This is a case where the board, and arguably as acting as a controlling stockholder, was displaced by the stockholder body writ large, which was allowed to exercise corporate democracy.
But isn't it the case that with the common corporate benefit doctrine, there's a three-part test? The suit has to be meritorious and filed. And then secondly, the action producing the benefit has to take place before a judicial resolution, which didn't occur here. So how is it that this case merits fees under that doctrine?
So, Your Honor, I would say that doctrine probably has the most salience in the mootness case, when the corporate action moots the stockholders' claim. Here, the Court of Chancery is the one that vindicated plaintiff's claim. But just like I would say in a typical class action, where there's a large recovery and there's a fee that comes out of that for the plaintiffs, this is the same thing. It's a therapeutic benefit, and it's a benefit in vindicating the stockholder vote. And as Kaiser versus Curtis acknowledged, in those circumstances, that can warrant a fee. In that case, the court didn't award one because it was controlling stockholder asserting its rights. But here, when the broader stockholder-based vote is vindicated, a fee is warranted.
Thank you very much.
Thank you, Your Honor.
Thank you, Your Honors. A few quick points. To start, I just want to be absolutely clear. We're not arguing for an alteration of the standard of conduct here. We're solely arguing for that we can alter that a charter can alter the standard of review. And my colleague on the other side claims that there's no limiting principle to that, but there clearly is. The charter here chooses one of the classic forms of the standard of review. It doesn't completely insulate the board from review. It applies a sort of well-known and classic business judgment rule standard, which, as I said in my opening, can be rebutted. I also want to address the point that my friend on the other side argues that we somehow are saying Corwin is dispositive here. We're not saying Corwin is dispositive here. The point we're making when we cited Corwin is that this is, when you're dealing with a charter, that's special, and the reason it's special is because all of the stockholders assent to it. And so in an analogous way, there's some sense in which it has similarities to the Corwin situation where you have an informed vote by the stockholders, but we're not arguing for a sort of super heightened Corwin application of the business judgment rule. The next thing I would say, Your Honors, is on the acting in concert definition. Our point is that the definition that the Chancellor applied here was unduly narrow. And just to take one example, why would she rely on the securities law principles rather than SIPCA, which is the clearly applicable federal regime? And so I think it's appropriate to look at the SIPCA definitions rather than those that the Chancellor adopted. And what shows that her definition was overly narrow is that essentially what it would require is a formalized agreement between the parties, and that would mean that only the sort of unwitting people who are sort of ignorant enough to actually formalize the agreement would be captured within that, and it wouldn't apply to people who are sophisticated parties that have arranged an understanding or an agreement without formalizing it in place. Also on this point, we clearly did preserve these arguments. I point you to trial brief, pages 10, 15, 24, and it was discussed at trial, this issue regarding SIPCA. I mean, the Federal Reserve had sent these letters that were key pieces of evidence, so SIPCA was all over the trial in this case. Next, I want to address some of plaintiff's arguments with respect to unit count. I would say that the argument you heard today would really prove too much, because essentially what they say is they win under unit count simply because there were some votes that weren't counted. But number one, that's not how unit count works. The question is whether the mechanism was reasonable and proportional. As we've explained in our brief and as I explained earlier, it was both of those things. But also, if you were to take plaintiff's argument at face value, they would lose, because the record shows that if the voting limitation was not applied at all, meaning that all votes were counted, their slate of nominees would have lost. Because if Mr. Usera hadn't applied the voting limitation to himself, that would have put the board's nominees over the top. That's also why the next point, which is that fees were inappropriate here, Your Honors, and one of the main reasons why is that they didn't vindicate the stockholder vote as an entire whole, because they would have lost if all stockholder votes were counted. They obtained a personal benefit for Mr. Johnson, i.e. Park, and the nominees who sued to obtain their seats on the board. And then the last point I would make, and I'm also happy to answer any other questions in my last minute, is that you can look at this on the paper record exactly the same way that the Chancellor did. You're fully situated to look at the facts as they were deduced, but I also would go back to my point that we're not quibbling with her findings of fact as she states them, i.e. that the Robb litigation happened and how she states the Robb litigation happened, that Mr. Johnson sold the shares on the eve of the record date and did so, quote, to beat the record date, and that he had previously identified Mr. Watson's shares as beneficially under his ownership. What we're saying is the application of her standard, which we already think was overly narrow, was also legally erroneous, because at a minimum, there was an understanding here. And then the last thing I'll say on that point is that we have no problem with that definition, because the transactions that the other side points to with respect to some of the directors are fundamentally different than a set of transactions that were aimed at electing the son of Mr. Watson, who is presumed to be acting in concert with her. Thank you, Your Honors.
Thank you very much for the arguments. We'll take the matter under advisement.
Please rise.